Thank you, Isa. Hi, everybody. Thank you so much for being here. A big thank you to Isa for all of the help leading up to today's Q Corner chat. And of course, a huge thank you to Q Corner. I love collaborating with you and doing these Q Corner chats. So thank you for having me. Um, as Isa just shared, my name is Christina Arregoces. My pronouns are she, her. I am a senior attorney in pro bono with the Law Foundation of Silicon Valley. And I am here today to chat with you about how to make your name and or gender marker change case confidential under a new California law known as SB 59. We're going to kind of get into how to not only make your case confidential if you are filing currently, but also if you've previously filed and you want to make it confidential retroactively. And we're just going to talk about your rights in general under SB 59. So my hope is that if it doesn't apply to you, maybe there is a friend or family member or loved one who you might be able to pass this information on to. So let's go ahead and get started. A little bit at the beginning about who we are. So, as I mentioned, I work at the Law Foundation of Silicon Valley. We are a legal nonprofit organization who serves Santa Clara County. We're located right in the downtown of San Jose, and we are very proud and honored to be able to provide free legal services to the community across our housing, health, children and youth, and pro bono programs. Our pro bono program is what we're going to be talking about today. It houses our transgender rights project. And in this transgender rights project, we provide free assistance from free pro bono volunteers who will help you file a name and or gender marker change case, make a case that is currently public, confidential under SB 59, which we'll be talking about today. And then we're also happy to be able to assist with updating and changing some identity document updates after you have received your court order. And just a note here, I will talk about this later, but we actually do have a remote clinic coming up on September 14th. That'll be at 5 p.m. The entire clinic is remote, so you can do it via phone or via video. But if you are interested in having free pro bono assistance in getting a name and gender marker change in Santa Clara County, or if you've already done that, but your case is public and it's not confidential and you want to make it confidential, we are looking forward to being able to assist you at that clinic. So if you're interested, I'll have some of the information later about how to sign up, but just wanted to flag that for your calendars. A couple disclaimers today. The first one is that I cannot give out legal advice today. If you do have specific case questions, please go ahead and call our intake line. I have the number there. Or if you'd rather, please feel free to fill out our application online. We just ask a handful of questions to be able to understand kind of what's going on, and then we will get back to you and work to try to pair you with a pro bono volunteer to assist you for free. I do have the link there. I'll also have it in a later slide as well, so don't worry about writing it down just yet. And then the second disclaimer is today I'm speaking about California law only. So SB 59 is a California specific law. It will not apply to other states. So just a good thing to keep in mind that today we're really just talking about California. All right, we're going to go ahead and start at the top. And I think kind of the most pertinent question is, why is the court even involved in the first place when we're talking about name and gender marker change cases? So essentially, each of your key identity documents, and some of the big ones are license or California ID, including the real ID, passport or birth certificate. Each of those identity documents is managed and overseen by a different government office. Some of those offices are state run, so California runs them. Some of them are federal, run by the federal government. Unfortunately, there is no one-stop shop where you can go and say, I would like my correct name and gender marker to be updated across the board. You do have to do it sort of piecemeal. And so in order to be able to update most of your identity documents to reflect your correct name or gender marker, you will need an order from the court. And that order is signed by the the judge, it gets a file stamp, and it legally changes your name and or gender marker. You'll notice I say and or for all of these situations because I do want to specify that all of what we're going to be talking about today applies to a name change for purposes of conforming to gender identity, or a gender marker change, or both. And so the order that you end up getting from the court basically acts as a kind of key that you can take to each agency. And when you show them the order, it again sort of acts like a key and it unlocks the ability to update each document with each individual agency. That's why we're starting kind of at the court level and why the court is involved. So your court order represents basically that legal change of your name and or gender marker. And just another note that we are speaking specifically here about name changes for the purposes of conforming to gender identity. If you or someone you know is seeking a name change for a different reason, like for example, adoption or due to marriage or divorce, or just because they want to change it for a reason that doesn't have to do with conforming to gender identity, there are different rules and different laws that apply. So I do want to specify that today we are speaking about for purposes of conforming to gender identity only. So, in order to get your court order, you need to file a petition with the court. And petition just means essentially the approved packet of forms that the court and the state lays out for what it is that the court is going to be reviewing. So, you will file your petition with the court, which usually looks like going in person to the clerk's office and providing them the forms that you have filled out, signed, dated, and you're asking for them to be filed and reviewed by the court. Once you do that internally, the court receives all of your documents and they create a case record file that contains your related petition forms. So all of them are there. They all get uploaded onto the computer, and they also get uploaded onto an online docket where people are able to go online and look at the forms. So the reason we're talking about SB59, the reason it's so important is because in many court cases in general, case records are considered public. That means that the entirety of the file containing the forms can be viewed. They can be viewed by anybody who's looking at them. They can be viewed in person at the clerk's office if you go in and say have the name of somebody, or maybe you have the case number, and you say that you would like to have a copy of a particular document or of the entire case file. And critically, they can also be viewed online. So I just talked about that online docket. We're actually going to see an example of what that looks like. But the general thing to remember is that most court cases, regardless of what they're about, are considered public. So that means that you are able to access them in person or online. And before 2024, unfortunately, virtually all name and or gender marker change cases were automatically filed publicly. So that means before 2024, if you were filing a name and or gender marker change case, you would go in person, present your forms, they would take the forms and they would upload them onto the computer. They would automatically get uploaded onto their online docket. And that means that anybody could see them if they knew your name or your case number. And it also meant anybody could go in person and request a copy. Obviously, this is a really significant safety and privacy concern. What we see very sadly is situations where that information might be found by somebody, whether a peer or a classmate or a coworker, or it might even be just found by a website online that kind of crawls the court websites and pulls these documents off. We're going to talk about that soon too. But the end result is that these documents, which contain really personal data and information that should be kept personal and private, could be distributed. That could lead to outing. It could lead to doxing, which is the posting of private, personal identifying information online. And of course, right, if you've done a name and gender marker change case or you've assisted somebody else, you know that in addition to information about the name and gender or sex that they were assigned at birth, that these forms also contain personal addresses, they contain email addresses, they contain phone numbers. So for a variety of reasons, right, the posting or dissemination of these forms could be really unsafe, and that posting or dissemination or sharing of the forms really violate a lot of privacy rights. So in 2024, in steps our first very positive privacy law. That is the Transgender Youth Privacy Act. It was also known as AB 223 at the time. It went into effect, and as a result, what happened is that all name and or gender marker change case records for minors became automatically confidential as soon as they were filed with the court. So that meant that as long as the petition was for a person who was under the age of 18, the second you handed those forms over to the clerk, they would be filed confidentially, which basically means that they're marked sealed or confidential by the court, and they are inaccessible to the public, either in person or online. So the only people who were able to go and request a either physical copy of those records or who could see them online were people who were directly involved in the case. This obviously is a significant win for the privacy rights of minors filing in 2024. It was a long time coming. It made waves. It was incredibly important as a step for privacy and protection. And it was basically the law and the state recognizing, right, that minors needed to have this protection, and this was really critical. However, what ended up happening, right, is that because we were protecting minors and minors only, two other groups remained unprotected. So their case records were still publicly accessible in person and online after 2024. The first of that group, sadly, were minors who filed before the law went into effect in 2024. So I have worked with families who sadly had filed even potentially like 2 months prior to January 1st, 2024, meaning that they did not receive the protection and that entire case record was public. And then the second set of folks who remained unprotected were all adults. There is technically a way that folks could request sort of an exception to be able to have their case sealed. That was if they could prove that they had been the victim of specific kinds of abuse in the past. If that were the case, they would be able to apply for a program that would allow the court to say, okay, we'll go ahead and seal for your protection. But unfortunately, there was a big gap there, right? Because that part of the law only focused on abuse having already occurred. And it didn't focus at all on the potential for doxing or outing or bullying. And because of that, it was very, very limited to a specific group of the population, and the rest of adults were unable to have their records sealed. So for many people, that meant a decision between filing and not receiving any protection or holding off on filing, which of course is a terrible decision to have to make and a very unfair one. So enter SB 59. SB 59 is a bill that was signed into law on October 13th, 2025. So the name of it, and we'll be referring to it today as SB 59, but just note that that is the name of the bill technically. Once it was signed into law, it became Health and Safety Code 103437. So you can look it up either way if you want to look it up online. But SB 59 allows adults to have their name and or gender marker change petition and entire related case file automatically made confidential as soon as the petition is filed. So this is kind of the law that stepped in and closed that gap that we saw left over by AB 223 that we talked about on the prior slide, which only affected minors. Now, regardless of age, any person who files a name and or gender marker change petition, it automatically gets made confidential from the second the petition is handed over to the clerk. So we're going to be talking today about what it is specifically that SB 59 does. It does three wonderful things. The first thing, like I just mentioned, is it makes all name and or gender marker change cases confidential at the moment of filing. This is as of July 1st, 2026. So of course we are in August now. We are past that date, meaning that from that point forward, as soon as you hand it over, regardless of your age, your name and or gender marker change case will be automatically accepted and made confidential. The second thing it does, and this is a critical one, is it allows minors and adults to make their previously filed cases, which are still public, confidential retroactively. So that means that even if you filed prior to, if you were a minor, either that 2024 law, or if you're any age prior to July 1st, 2026, you now have the right under SB 59 to ask the court to go back and make that public case confidential. Because if you didn't file after either of those dates, it is still going to be public currently. And the third thing it does, and we'll chat about this, is it creates a penalty if somebody discloses or publishes your case documents or information without your consent. So again, just a really good kind of protective prong there, which kind of gives some teeth in the event that somebody is still trying to utilize your confidential information and disclose it to others. So let's talk first of all about what confidential really means. I wanted to include a sample here of what a court docket search looks like without confidentiality. And just a reminder, when we talk about the court docket, that's really just sort of a part of the court's website that shows all of the upcoming hearing dates and the cases that are heard on them. And you can click into those individual cases, which will, depending on the case, allow you to see details. So this is sort of a snippet from a detailed page of the court docket. Obviously, this does not contain anybody's confidential information. It has no information that can be traced back to anybody here. I just wanted to be able to show a sample. So you'll notice here that at the top of the form, and I've underlined them in red, it says in the matter of sample name, and then there's a sample case number. Already, right, those are two pieces of information that would be publicly disclosed and accessible. So let's say that we had a real person's name here. Let's say their name was Cameron Jones, and that is the name that they were given at birth. So that is their current legal name at the time, and they are looking to change their name to conform with their gender identity. So here it would say in the matter of Cameron Jones. So already that's directly connecting their name. So that's something that's searchable online. And it would also have their case number. So if anybody was able to connect the case number with their name and their identity, they'd be able to search this online docket via either their name or identity and case number. You'll see underneath too, it shows you each individual event. So typically what this is showing us is it's showing us each individual form that's been filed in the case. So in this sample, right, it'll tell us the date that something was filed. It'll tell us what it was. So here it's an order. It'll tell you again, filed by, it'll have that name. So Cameron Jones. There might be a comment here. We don't see any. But critically and most importantly, prior to 2024 for minors, and then prior to July 1st, 2026 for all people, you would be able to see the documents. So you see there, we have a little PDF insignia. Those are clickable on the court docket. So if I were to search somebody real right now who had a public case, I would be able to click into those PDF documents, and I would be able to look at everything on the document page, which would show their current legal name. It would show their sex assigned at birth. It would show the name that they were requesting be ordered via the court. It would show the gender marker that they're selecting moving forward. It would show address, phone number, in some cases, place of birth, date of birth, right? So a lot of information that really should be protected. And just a note here, while I am an attorney, I took a screenshot of this page while I was not signed into the case docket, meaning that this is the same view that any member of the public would have. You don't need to have a login. There's no paywall. You could just look it up and see these documents. So this is a court docket search without confidentiality. This is what SB 59 has created protections against, so that this is no longer what we're seeing. However, for folks, again, who filed before the change in the law, this is still what you would see if you looked it up. And this very simple, succinct screenshot of the portal is exactly what the court docket looks like with confidentiality. So you will see that had I searched Cameron Jones's case and I put that into the search, either by Cameron Jones's name or by the case number, you will see instantly what I met with is an unauthorized insignia. And so this is telling us the case cannot be viewed online. You must come directly to the court. If you go to the court will ask you who you are. They will ask to see an ID because they need to verify that you are somebody who is connected to the case. And we'll talk more about who those people specifically are in just a moment. But I just wanted to show the difference between what it looks like when we don't have confidentiality and you can click every document, and then what it looks like when we do have confidentiality. This is what it will automatically look like now if you file for a new name and gender marker change. However, if you filed previously, this is what it looks like until you ask the court to make it confidential retroactively. So we just talked about, right, that there are some people who are able to still access the case when it becomes confidential, but these are only the people who are related to the case. So the only people, if you, for example, were to go into court and say, I want to see a copy of the case file or a specific page or order, the only people who the court would authorize to do that, and they will check your ID first, is the petitioner, which just means the person who asked for the order, so the person whose name is on the order, a minor who received the order. The reason I separated that is just because for petitions for minors, the petitioner is actually technically the parents of the minor or the guardian of the minor or another family member in the event that parents or guardians are not in the picture at the time. So in this case, right, it could be the petitioner, it could be the parents if they filed on behalf of the minor, but the minor, of course, is able to still request to see and get copies of their order. Any adult who signed the petition, which again would just be a family member petitioning on behalf of a minor, any attorney representing any of these individuals, if there was one, and then any agents acting pursuant to written authorization from those individuals or their attorney. So, for example, if you sent a process server down to court to pick up some copies for you and you wrote a note stating that you are authorizing this person to pick up copies on your behalf, the court would verify their identity and they would feel comfortable moving forward. You'll notice, of course, no member of the public is on this list, and that is where we see the safety and security and protection under SB 59. I just wanted to include a quote here. Senator Scott Wiener is the senator who brought this bill forward. It was his bill. And I just wanted to include this quote. He stated once the bill passed, as the Trump administration attempts to make transgender and non-binary people the scapegoats for their fascist takeover, California must stand up to protect them. Right-wing groups and individuals have used publicly available personal information to harass trans people in California and across the nation. There's no reason this sensitive information should be public, and I have every confidence Governor Newsom will ensure the transgender community receives this basic protection. So he shared that in 2025, and then of course we know that it was passed. So now kind of jumping into how do we use it? So we know what SB 59 is, we know why it's so important, and we know the actual difference that it makes when we see it on that online docket. So let's talk about how we use it. And again, because SB 59 has three parts to it, we're going to talk about each of these three scenarios and how it applies. So for scenario number one, we are talking about the first prong or kind of first rule of SB 59. And that is that in this scenario, you would find yourself utilizing SB 59 when you file for a new name and or gender marker change. So this could be the first time that you're filing. It may be the second or third or fourth, right? If you are filing for a new name and or gender marker change, you can file as many times as you'd like. And always, of course, right, what we're talking about today is for the purposes of conforming to your gender identity. So the context behind scenario one is that you are filing a petition with the court for a name and or gender marker change, either for yourself as an adult or you're an adult who is filing on behalf of a minor child. How do we use SB 59 in this case? It is the easiest answer of all. It is that it will just automatically apply. So as soon as you file your petition and hand it over to the court clerk, both your petition and the entire case file will be confidential from the start automatically. What forms do you need? None whatsoever. You don't need to submit any form that is different from the ones you're already submitting. You don't need to say anything special to the clerk. You don't need to let them know anything about SB 59 or that you want it to be confidential. It happens automatically. So nothing that you have to worry about saying or doing differently. And I always recommend that you just double check. So once you go ahead and file your forms, if you're doing it in person, then you're going to receive most of them back same day with a file stamp. Of course, you won't receive your order back yet because the judge is going to review that and will ultimately make a decision on it in about 6 weeks from the date that you file. But you will get a number of those forms that you just handed over. You'll get a copy of them back with the file stamp. And included on the page will be a case number. So if you want to confirm that your records are confidential, you can do it the minute that you leave the clerk's office. You could just kind of pull over and pull up your phone and look it up. But what you'll do is you'll go ahead and type in your case number. You'll go to the website of the court you filed in first. So if Santa Clara County, I do have the website for that. It is a portal at scscourt.org. And it'll basically just pull up a search box. And one of the search boxes will say case number. So you'll pop your case number in that you're seeing on your filed document. You could also search your current legal name, the name assigned at birth, or the case number, whichever one. And you should automatically instantly see that authorized style notification. So it'll say unauthorized, the one we were looking at before. If you see any part of your case or any identifying information, so if you see your name or anything that you filed or a little PDF that you can click on to show you one of the documents that's just been scanned in, you should go back to or call the clerk's office immediately to tell them because that means that there's been an error. I have not seen these since SB 59 went fully into effect. So I do not anticipate that you will have that happen. The courts are well trained on this, especially in this area in Santa Clara County. They are very aware of how important it is to make sure that all of these petitions are getting entered as confidential the second that they're handed over to the clerk. So I do not anticipate that you would see that, but I always recommend double check just to make sure. And if you see an error, call the clerk's office, let them know your name and your case number, and let them know that you filed for a name and or gender marker change and that you are seeing any part of that case online, so it is not confidential. They should fix it immediately and remove it to make sure that you receive that unauthorized notification online. If you are nervous to call the clerk's office, that's totally understandable. And you want some help, and you can always reach out to us at the Law Foundation. I've put our intake number on there, as well as our Transgender Rights Project page website. So you'll just go to lawfoundation.org, find our Transgender Rights Project page, and then you can fill out an application and let us know what's going on. But definitely feel free to move on that very quickly. If you do see any of your case information, we will step in and we'll assist you in bringing that to the court's attention. But again, none of that is anticipated, just always good to double check. So now we are moving on to scenario two. In scenario two, this is a situation where you filed for a name and or gender marker change before July 1st, 2026, and you want to make your case records confidential now. So this is kind of that word we've been using previously, which is you want to make them confidential retroactively, which just means after the fact, after the filing. Unfortunately, SB 59 did not make it automatically confidential retroactively. So there wasn't really a way to be able to have all courts go back to all of the cases that have ever been filed and update them in a cost-effective and efficient way. So SB 59 does not include that. What that means is that if you did file for a name and or gender marker change case previously and it's currently public, SB 59 gives you the right and the ability to ask the court to rectify that and make it confidential. But it does mean, unlike kind of scenario one, right, where you're filing for the first time or you're just filing at any time after July 1st, 2026, in this second scenario, it does put the onus on you to have to go to the court and say, hey, my case is public because it was filed previously, and now I want it to be made confidential. So, in terms of context, right, if you're in this scenario, it likely means that either you filed for yourself as an adult before July 1st, 2026, or you filed on behalf of a minor before January 1st, 2024, or an adult filed on your behalf before January 1, 2024, when you were a child. So it's your petition, and now you're an adult and you're looking to make it confidential. So, how to use SB59 in this context? You basically will need to file one form with the court. It is a singular form, it is just 2 pages. You don't need anything but that form. And if you are self-represented, meaning you are doing this on your own, not with the assistance of an attorney, that's of course totally fine. They do make it still quite easy here, but you'll probably be going in person if you're self-represented. So you'll take that form, you'll fill it out, and you'll bring it to court, and you'll ask for it to be filed. You'll hand it over, and the court will file the form. The judge will review it, and they will grant your request. So they have to grant your request as long as that form is filled out properly, and we'll take a look at how to do that in a moment. But just know that it's not a situation where the judge has to think about it. Under SB 59, the judge must make it confidential if they receive that form from you. This form, you might hear it referred to as ex parte. Some people will say that it's an ex parte form. Ex parte just means that there's no other party involved. You don't have to serve it to anybody. So you just will take the form, print it out, fill it out with your information, and bring it directly to court. You don't need to give it to anybody else. It is very importantly, this form is free. So in order to file it, there is no fee assessed at all. They cannot charge you for filing it. I have a note there, call us if they attempt to charge you. Again, I have not seen that in Santa Clara County. In some other counties throughout the state where there perhaps has been a little bit more of a lag, sadly, for the clerk's office to sort of understand the entirety and the judge to understand the entirety of SB 59. I have heard of circumstances where they are requesting a fee. We'll look at the form together in a moment, but you'll see it says directly on the form that there is no fee to file. So if you get any pushback, you can raise it to the court and just say, hey, there is no fee. If you don't want to do that at the time of filing, totally okay. Feel free to reach out to us and we will assist you. This form also gets automatically filed confidentially. So that means that both this form and then everything in your case file will be made confidential. You don't have to worry about just this form showing up. Of course, that would defeat the purpose. What form do you need? It is called the NC015. It is a statewide form, not just specific to Santa Clara County. And I did include the link there for how to find it, but you could also just Google NC-015 court form and it'll pop up there at the top. It'll be on the California court form website. Again, here, once you go ahead and file your NC015, it might take the court a little bit of time to review it and to grant it. I would give it a couple days, and you can always call the court and check on an update. But basically, again, the court has to grant it. The judge will absolutely grant it. And then once that happens, you can go online again on your court portal, and there's the link for the Santa Clara County one, and you can search your current legal name or the name that was assigned at birth that you changed your name from, or your case number from that original petition, and you'll be able to see it. So again, that initial kind of court docket form was the one that we were looking at when we noticed that it was not confidential. You could click on everything. You could see a name. You could see a case number. If it is made confidential, you'll see that unauthorized screen that'll pop up. So that's how you know that the NC015 was processed and ruled on and granted. Again, it does happen pretty quickly, so keep an eye on that. You can keep refreshing. If more than a couple days have gone by, I do recommend calling the clerk's office. I did include the clerk's office filing number right there for Santa Clara County specifically. And if you're having any trouble or any pushback again in Santa Clara County, you can always give us a call at the Law Foundation and we'll take a look at it and step in to communicate with the court on your behalf. This is a screenshot from the form. So this slide and the next slide are both actually the same first page. I just broke it down into 2 chunks so that you can see it a little clearer. But you'll see everything in blue here is what you'll be filling out. So at the top, if you are self-represented, you'll fill out your current legal name. Your address, city, state, zip code, phone number, email address, all of that is just so the court can get in contact with you if there's any issue. But again, remember, this form gets filed confidentially, so you don't have to worry about any of this information being visible at all at any time. You will fill in the address and county of the court that you're filing in, and it's a good idea to go ahead and file in the same county that you filed the initial petition in. That way they can link it to the case, right? And they'll know and they'll have the ability to change it. So you want to put the same county that you initially filed the name and or gender marker change case in. And then for the petition of, you're going to go ahead and write down the name of the adult person who made the initial request of the court. That sounds kind of complicated. All that I mean by that is that if you previously were an adult at the time that you filed your petition, you'll put your name down. But if you were the minor or you're an adult who's filing this on behalf of a minor who you previously filed for, then the adults are technically the petitioners. So you'll go ahead and write that name down. The case number over here to the right will be the same one from your initial petition, again, so they can link it back. And then you'll see here, right, we spoke previously about how this form is used when requesting a change to something already on file with the court. And you'll see underneath there's actually a note to clerk. I love that they wrote that in there. It's bolded and it says this request may be made ex parte, which again means we don't have to give it to anybody beforehand and without a filing fee. And they actually link the exact law there. So that's something you could point to if you ever hit any issues. I don't anticipate that you will, but it's clear as day right there for the clerk. Underneath, you'll see item 1 asks for on a date the petition was filed to. So you'll put the date that you initially filed your petition for a name and or gender marker change. You can find that date typically up in the upper right-hand corner underneath that box that says for court use only. Just take a look at your original documents and you'll find it. And then underneath, you'll check the relevant box. So it says a petition was filed to, you have to check 1, either change a person's name and recognize a change of gender, or recognize a person's name, a person's change of gender, or change a person's name to conform to their gender identity. So you'll just click whichever one you previously petitioned for. And then you'll fill out more information underneath. It says the petition was filed in the Superior Court of California, County of. You'll include the county that you filed in initially. It was assigned the following case number. You'll pull that same case number, and it was sought to change the name or gender and sex identifier or both of the following person. So you will include your current name or the current name of the person who you're trying to make the forms confidential on behalf of. So remember, this is just the second half of the page 1. But you'll see here, item 3 says my name is, you put your current legal name. And I am, and then you'll check here. You'll check A if you were the petitioner who filed for yourself. So that's if you filed as an adult previously. Or you'll check B, which says parent, guardian, near relative, or friend who signed the petition listed in item 2, which was brought by or on behalf of a minor. So that is what you're checking if you brought the case on behalf of a minor to help them change their name and or gender marker. Or of course, if you're represented by an attorney, they'll check C and say that they are the attorney for the petitioner. Underneath 4, it says the court has either A, ordered the change described in item 1, which means that they did grant your name and or gender marker change petition, or B, not ordered the change. That means that the court denied it. That's an important distinction because even if the court denied it, if it was before 2024 for minors or 2026 for adults, even though it's denied, it'll still show up publicly, and that's still information that you'll most likely want to not have show publicly. So whether or not the court granted it, hopefully they did, you'll go ahead and check A or B under item 4. And then item 5 says, I'm asking the court to make the petition listed in item 2 and all records associated with the petition confidential because item A, the petition listed in item 2 was filed before July 1st, 2026, or the petition listed in item 2 and other records in that proceeding were previously made confidential, but they're not being kept confidential by the court. So most likely here, and hopefully you'll just be checking box A and you'll just be saying, hey, it's because the petition was filed before July 1st, 2026, which we know is before SB 59 went into effect. The second box is if you find out that the court did not make your records confidential even after July 1st, 2026. So essentially, you legally have the right to that protection, but the court isn't following the law. This would be a good way to bring it to their attention formally. I do think that an initial step could be just bringing it to the clerk's attention without having to go through the act of filing this, because the clerk might take a look at that and realize it was a mistake and make the change. Again, if you're in Santa Clara County and you realize that this mistake has happened, you can flag it for us and we'll assist you. However, if, for example, you are in a county that does not seem to be following the law, no matter how many times you bring it up to them, then you should use the NC015 and check that box. You'll also notice under 5B, it gives you the potential to attach a form MC025 to provide additional information. The MC025 is really just a declaration sheet. It's blank, so you can write into it. But that would be where you're writing and saying, for example, I am able to have the right under SB 59 for my previously filed petition to be made confidential. The court is not complying with that law, and I'm bringing it to your attention. Item 6, you'll just write in the number of pages you've attached. So most likely you will just be writing 0. You don't need to attach any pages. But if the court is not respecting your right under item 5B, then you would write in, for example, just 1 for the additional MC025 page. And that is really the substantive piece of this form. The second page, this is just a chunk from the second page. The rest of it is blank. It's really just a signature page. So you'll include, again, the petition name, your case number that you did on the first page. If you are the adult asking for your own petition to be made confidential, you will include your own name and you'll sign it. And that'll be your current legal name, so the one that was changed. Or if you were, say, multiple adults, like 2 parents or 2 guardians who petitioned on behalf of a minor, then you'll both write your name there and you will sign. It's also important, again, as I mentioned previously, that you can still absolutely ask for this on your own behalf if you are currently an adult, even though somebody else petitioned for you when you were a minor. You don't need to have that other adult make this request for you. You can make it on your own behalf since now you are an adult. And if you're still a minor, you can have the same parent who petitioned initially make this request on your behalf. So that is how we use SB 59 under scenario 2. We are now going to look at our final scenario, which is that you have a petition and case file that is made confidential, and you learn that somebody has published, shared, posted, or disclosed your name and or gender marker change case information without your consent. So again, the context is that somebody's posted it. Maybe they've done it online. They've doxed you, right? Which I hope never, ever happens to you or anyone you know. But sadly, that can occur. Or they shared it with other people. Maybe they shared a link to the website. Maybe they posted it online. They emailed it, right? Any method. Or they disclosed your actual case documents or records without your consent. Again, this can happen either online or in print, so the method doesn't matter, just as long as they know that it was a confidential document and they shared it anyway. It could be somebody who's known to you, or it could be a third-party website. I talked or alluded earlier to sort of a third-party legal AI website. Unfortunately, those have been more and more common recently. What I'm talking about there is you've likely seen it if you've ever looked up a court case, but if you Google information about a court case, you'll often see these third-party websites that sort of are marketed as an easy search tool for lawyers or law offices a lot of the time. But of course, they are also used by the public. And what they do is they utilize AI to sort of crawl online and look at instantaneously court websites and court docket pages. And they will grab the information as soon as it's publicly posted, and then they will host it on their website. So the unfortunate thing about that is that say hypothetically, right? Again, I don't anticipate this happening, but hypothetically, the court accidentally filed a case publicly that it was meant to file confidentially. Even if the court recognizes that mistake and changes it within, say, an hour or so, a lot of those third-party AI websites can still grab it and host it. The negative thing, right, of course, is that that means that the public are able to access it, even if it's behind a paywall and you have to pay to access it. A lot of the time, you can just sign up for like a 2-week free subscription, which allows you to pull what you want off, and then you can cancel it without getting charged. Um, so obviously, right, that contains really significant privacy and safety issues. The positive thing now is that we have sort of the teeth of SB59 to be able to go to that third party website and say, hey, you are in direct violation of a California state law. This needs to come down and it needs to come down now. And if not, there will be penalties. That's what the third prong of SB59 says. It says essentially that you are able to seek penalties against somebody else or damages against somebody else for publishing or disclosing your confidential information related to this case. There are a few ways you can do this, and I do want to note that for this one, unlike our first two scenarios, you may want to consult an attorney because depending on the damages case, it could get a little more complicated. But the first thing that you could do if it's not an immediate, instantaneous requirement that you need to have it taken down that moment is you could send a cease and desist letter that references SB 59. We can assist you with this step. We have those letters ready to go. We have utilized them for those third-party websites, and they have taken them down immediately as soon as they receive them. I do want to say, though, of course, because you're sending a letter, it could be, however many number of days it takes for them to receive it and review it, and then they take it down. So again, if you need to have it down instantaneously, you may not want to start with a cease and desist. You may want to start with asking the court for an order. So SB 59 tells us that two things that you can do. One is you can ask the court for a takedown order, meaning that you can sue the other party at court and ask for an order that the third party take down the documents immediately per SB 59. And if you have to pay any fees in order to do that, the law also says that you can ask the court to make an order that the other party has to pay any fees or costs you incurred as a result of enforcing SB 59. The second thing you can do is you could actually sue for damages. What this means is that you can sue at the court and you can say that you have sustained harm because of the disclosure by this third party. Again, it could be a website, it could be just a person known to you, a person not known to you, it doesn't matter, any third party. So you're telling the court that you have sustained harm and you'll need to prove that harm. And once you do, you can recover monetary damages for your invasion of privacy. You could be awarded actual damages. So if there were literal damages that you faced as a result of this information going out, whether it's property damage, maybe you had to take time off from work, right? Maybe you lost your job, right? Whatever that harm is, you can show to the court, or $5,000, whichever is greater. And then as a sort of additional step, if you're able to prove to the court that the behavior was malicious, you might actually be able to be awarded punitive damages, which can be very, very high. Those are basically damages that are sort of meant to be punishing, right, to the other party. So again, right, especially for what forms do I need here, it's not as straightforward depending on the case because you might be filing in one court versus another. So you may want to consult an attorney. There are some plaintiffs' attorneys who work on a contingency fee basis, which means that you don't actually have to pay them until and unless you collect money kind of on the back end from the court. Or you may be able to be represented by a pro bono who doesn't charge regardless. So this is sort of just that third scenario on SB 59. But again, if you are looking especially for the damages piece versus just a takedown order, you may want to consult an attorney. But the positive piece is that SB 59 does give us those teeth and that very clear penalty for anybody who is looking to potentially try to disclose your protected information. A little bit here just about what help the Law Foundation provides, and then I want to open up to a Q&A, so feel free to pop anything in the chat if you haven't already, or in the Q&A portion of this webinar. But at the Law Foundation, we do provide free assistance through a pro bono volunteer who can help you file a name and or gender marker change petition, whether you are a minor or an adult. We can help you use that order to update some of your key identity documents like your birth certificate, your license. We can make your previously filed records confidential under SB59 by drafting that NC015 form for you, walking through how to submit it and getting it back, confirming that the court followed the steps under 59. And we can also write a cease and desist letter regarding unlawful dissemination or sharing under SB59 by a third party. I have listed again here our phone number. This is our intake line, or you can fill out our online application. There is the website. Basically, what to expect. We'll review your case, and if we're able to accept it, we will try to connect you with a free pro bono volunteer. This is somebody who is a trained professional who has given their time for free to assist on these cases. They are mentored by our pro bono senior attorney, who is me, and they keep all of your information entirely confidential. They won't represent you directly as your attorney, but they give you the information and draft any forms on your behalf and support you throughout the case process. So it's very similar to having an attorney, but your name will still be represented or stated as self-represented on all of the forms, but they will be there for anything that you need throughout these processes. And then just one last piece before we get to the Q&A, I have listed here an out-of-county resource list. We did not compile this. This was compiled by the California Rural Legal Assistance. They are CRLA. They are wonderful. They have done a lot of work behind SB59 and help making SB59 what it is now. This is just a site. You can see this on their website, but it's just a list of all of the different resources of legal organizations that can assist with these types of cases. Just in case you or somebody who you know is not in Santa Clara County, you'll see us listed there as a Santa Clara County resource. But if you want to share this with somebody else, say you know someone in Mendocino or Shasta, right, and they need assistance, please feel free to send them over to this page or take a screenshot of this one so that they can get assistance too. And now I will open it up for just a Q&A. If anybody has any questions about anything we talked about today, I am more than happy to answer. So feel free to pop them in the chat or let me know. Okay, it looks like we have a few on the Q&A. Let's see, the first one is, I had a name change for gender identity purposes in San Francisco County in 2021. Will we get a walkthrough today of how to request the sealing of the records? So yes, you will go through the same process there. You'll use the NC015 form. That's a statewide form. So that means that it also will work in San Francisco County. If you would like assistance there, I do believe that we have yes, there we go. We've got for example, the University of San Diego name and gender marker change clinic. It's statewide. So if you do want assistance in San Francisco directly from an organization, you can definitely find that. But otherwise, you could just go ahead and file your NC015 there. Great question. We have another question. I'm mindful that legal advice cannot be given for those of us outside of Santa Clara County. Would information provided apply, or do things vary county to county? Great question. So if you do want that assistance, again, I would refer you to this out-of-county resource list, so that way you don't have to do it alone. But just know that these forms, what we're talking about today, the right to be able to have a name and gender marker change petition made confidential automatically applies anywhere in California. You don't have to do anything for that. The right to have it made confidential retroactively applies anywhere under that that NC015 form. So it does apply there. But if you are looking to seek penalties or damages against somebody for dissemination, I would definitely recommend reaching out to an organization or a lawyer in your county for additional information and assistance there. Another question, I filed a combination name and gender change document. In most cases where I need to share my court order, I only need to share my name change. But in doing so, it naturally shares that I've also changed my gender. Do I have options to get a separate name change only court order? Thank you. That is a really good question. I have seen that before just a couple of times. It's a tough one because it would basically mean that you would have to file for another name change. They don't, unfortunately, at this time have a separate order that has been created for you to be able to only show the name change. So if you were requesting and filing again for a different name change, then you would be able to do that. There are different forms that still allow you to make a name change for purposes of conforming to gender identity. But as of now, unfortunately, there is not a separate order that would already be existing. You could always try to redact those portions, right? It depends on who it is that you're trying to share the document with. But if it isn't a super formal organization or agency, it certainly should be within your right to redact information you don't want to. And if they push against that, you might want to talk to an attorney. But I do wish they had that separate form. That's something that we certainly have been hoping for. Oh, we've got an error from the slide. It looks like a 404 error. That is for the court form. Let me pop that in the chat just in case, but it is the NC015 form. Oh, and we have another comment. Go ahead and Google just NC015 California should be the first result. Do you have a diagram of the form with the annotations of how to fill it out, or can I pull it back up for a screenshot? Yes. So I am more than happy, Isa, if Q Corner is comfortable sharing the slides. That is perfectly fine with me. So you may be able to find those on the YouTube or otherwise hosted by Q Corner. Otherwise, let me just hold this up for a moment. Please feel free to screenshot this, and we'll have the second page here. And then this third page here. And I'll go ahead and just leave it kind of resting on the first page since that is kind of more of where we see the meat and potatoes. All right, another question. How does a change of passport, pre-check, et cetera, preserve confidentiality? That's a great question. So when we're talking about confidentiality here, we're talking about confidentiality that the court is keeping in terms of your petition and related documents. Once you take that order to other agencies, right? That their kind of steps in terms of how they keep their information varies by agency. So if you did want to change your name on a passport, unfortunately, right now, under our new federal rules, you cannot change your gender marker on your passport, even if you have this order. ACLU is actively involved in a lawsuit. They're doing wonderful work there. So keep an eye. Hopefully that changes as soon as possible. But you are able to update your name using this order with the State Department to get another passport. You can use your name, of course, right in this order to sign up for pre-check. Once you do that, you are still sharing your information with those agencies. It just means that the public isn't able to view any of these court papers or your court file at the original court that you submitted. So there are still steps to be able to make those changes, but SB59 doesn't provide confidentiality within those agencies. And then we have another question. Since the process takes several weeks, how risky is it to initiate this process just ahead of the coming election? Could this potentially impact your voter registration? That's a great question. I am guessing that this has to do probably more with the name and gender marker change petition, the original one, versus the NC015. Because if you are just filling out the NC015 to retroactively make your initially filed petition confidential, then there shouldn't be any risk there. All you're doing is you're just taking it off the court website and you're making it so that third parties aren't able to see. However, if you're talking about the underlying petition, it does take 6 weeks approximately from the date that you have filed it. Only at that point will you have the court order. And once you have the court order, again, because we talked about the fact that agencies, there is no one-stop shop where you can just take the order or where the court kind of sends it out to everybody and it changes anything. You have to take your order like a key to each individual agency and have it changed. The first agency that is typically recommended to change, to bring your order to, is the Social Security Administration. They have to update your name there before you can go get a name change at the DMV on your license or California ID. So typically it is recommended to start with the SSA. There it is a little bit of a sort of timeline game, right? Where if you are concerned that you won't be able to get, for example, your ID back or a passport back in time, which can take some time, you may not want to go change it immediately, but that doesn't mean that you can't file. You can still file, you can get your court order, and then you can just basically take a look at the time and determine when it is that you want to take the order to these different agencies to make the changes. You can always call the individual agencies and ask. For example, I know very, very recently in this last month, the SSA had virtually no waiting period. They shared that they updated it internally, so it would be updated, their name would be updated internally within 48 hours, and a new social security card would be sent out within, I think it was 5 to 7 business days. So sometimes they move a little quicker, sometimes slower. So I would recommend giving a call to those agencies just to get a feel for what the timeline is. But it doesn't mean you have to wait on the court steps. You can file, get your order, and then just hold off on bringing it to different agencies until you're ready to do so. We've got some other questions in the chat. Let's see, on the top half of the first page of the 015 form, it has a blank area for petition of a name. Do we put our old name on that or our current and new name? So here, the best thing is to put the prior name that was associated with the initial petition. But the reality is that even if you put your current name that was changed, the court should still understand it. The clerk might point it out and kind of share which their preference is in the moment. But either way, as long as you have the right case number, and then underneath you're writing what your name previously was a little bit lower down, then you should totally be fine there. Another question on Form 015, first page. In the first portion, ask attorney for self-represented. Do we write out our name or write self-represented? Great question. You will write self-represented specifically. On the 015 first page, oh, I think that same question was submitted twice. And then another question. Years ago, when I originally did my name and gender change request, it was filed and accepted. However, the court input my name with the wrong letters of the name. And later, they provided me a corrected form with the correct spelling of my names. With this in mind, will I have to apply the NC015 form to both my corrected case file and my incorrect case file? Really good question. I'm glad that they helped you and gave you the corrected one. It'll come down here to whether or not they gave you two separate case numbers. My guess would be that they didn't give you two separate case numbers. It's probably just one case number, and then they made an amended one because they realized that they had mistyped into it. So if you look at both collections of those forms and you see the same case number, you'll only need to submit one NC015 form. But if you see two different case numbers, which would be less likely, then you would have to submit two, one for each case number. Another question, am I able to file the NC015 to Santa Clara Superior Court if I filed my name change at a different court county? So that's a really good question. If you are basically, the short answer is if you file it in the county where you previously had the name change, that is going to be the better step. Even though you're living in Santa Clara County, you have the right to be able to file, for example, for a new name and gender marker change here in Santa Clara County. But the court is probably going to be looking kind of at their own county records to be able to update them. So I would start at your the place that you initially filed, because I think that they would probably kind of kick you back there so that that court could go ahead and make the change. So say that that was really any other county, right? In San Francisco, Alameda, right? You'll want to go ahead and do it there, but it's going to be the same form. So it's the NC015. It'll be filled out in the same way that we talked about today. You'll just go ahead and submit it. You'll check online on their website to see that it has been made confidential. And again, if you have any questions, feel free to reach out. I think we might have just one more perhaps in the Q&A. If your name change is doxed but not directly referencing the court orders or recourse through SB59, yes. So if you, and I assume, right, that what we're talking about is that a third party was able to find your name and they doxed you. Basically, you would have to be able to prove that they sort of knowingly utilized this information that was confidential. So I guess what I would say there actually is I would say best probably to chat with an attorney about that, which it is kind of best in general to do for that third scenario anyway. If the attorney can prove that they were aware of the name change and utilized information from it, even if they didn't post the actual records, then yes, those SB59 provisions still apply. It just might get a little bit dicier if maybe they found out that information from another source and they didn't know that it was confidential. That's where you might hit an issue. So I would recommend chatting with an attorney about that. And then is there an expected processing time for the NC015 form? Not a specific one. Because it's ex parte, all ex parte forms are sort of reviewed and decided upon in a much quicker turnaround. Usually the court has about 24 or 48 hours to do that. This is a different kind of form that's newer to the courts, but I would recommend checking within a couple days. And if you don't see it come up as unauthorized online, then I would reach out to them. So the short answer is it should be dealt with sooner rather than later because it's ex parte. It should be dealt with within a business day or so. But sometimes that doesn't happen. So it's always okay to call up and say, hello, I'm just checking in on the status. This is the date that I filed it. Can you please give me an update or can you give me a projected time? And again, if you're hitting kind of a lot of issues there or kind of any pushback, feel free to reach out to us. And let's see, is there a place we can get a copy of the slide deck and the forms in it? So you'll find that NC015 form online, and I will pass it over to Isa. I'm more than happy with the slide deck being shared with anyone and everyone. So Q Corner, if they are able to post this, then that would be wonderful. Oh, it looks like Isa said we'll upload the recording to the Q Corner YouTube page. Perfect. So you will be able to find it there. And again, if anyone has any questions in Santa Clara County, please reach out. If you are not in Santa Clara County, I hope that this form made by CRLA is helpful. But if for some reason you're in a different county, you can always still reach out to us and we'll do our best to connect you with assistance in another county. I think that may be all of our questions. Thank you again, everyone. I apologize for going a little bit over time, but I appreciate everybody for being here and thank you for those very thoughtful questions.
Yeah, thank you so much, Christina, for sticking around and making sure all the questions were answered. And yes, we will absolutely post the recording or upload the recording to our YouTube page so folks have access to this. And Christina, if you're happy or willing to share the slides, I'm also able to email those out to folks who registered since I have those emails. So we can do that too. But yeah, thank you so much for all this great information. And thanks, folks, for joining.
Thank you. Thanks, everyone. Thanks, Isa. Great being here.
Have a good night.
Thank you. You too.